Welcome to the deep dive. Our mission is to take these really complex legal timelines, these surprising policy failures, and just distill them into the core knowledge you need.
Exactly.
And today we are undertaking a very detailed and, frankly, a pretty difficult look at the case of Brandon Hargrove. She was a former high school English teacher who once held the title Teacher of the Year at Brazoswood High School down in Clute, Texas.
And this deep dive, it's particularly challenging. I mean, we're talking about a timeline that stretches almost 2 decades.
2 decades. It's incredible.
It is. And it all culminates in a legal resolution that, it raises some really profound questions about accountability.
Yeah.
Especially in these educator misconduct cases.
Okay, so let's start there. Let's unpack this, because to really get the level of institutional trust that was broken here, we need to talk about Hargrove's standing in the community.
Absolutely.
She wasn't just a teacher at Brazoswood High. I mean, she was an AP English teacher, a former Teacher of the Year, and her family was, well, they were deeply woven into the district's entire structure.
That level of community integration is so critical to the story of betrayal here. Hargrove and her husband, they were actually founding partners in the Brazosport ISD Education Foundation.
So the fundraising arm for the district.
The key fundraising arm, yeah. And on top of that, her father, Jim Martin, was the former mayor of Lake Jackson. He himself had been honored by the Texas Education Agency as a hero for children.
Wow.
So when allegations surface against someone with that much institutional goodwill, the shock just ripples through the entire community.
So if that was her professional context, this pillar of the community, really, what's the timeline of the actual...
The actual offense, yeah. So the abuse occurred between 2007 and 2009.
Okay.
The sexual relationship started when the victim was just 15 years old, a student under Hargrove's instruction at the school.
At the time, she was her teacher.
At the time. And it continued until the victim turned 17. Now, the specific incidents in the indictment, they happened off campus. But the entire relationship existed within that framework, that power dynamic of her being the student's teacher.
And the part of this that's just, I mean, it's staggering, is the delay. The delay in the reporting. This didn't come to light until the victim was well into her 30s.
Exactly. The victim, now 34 years old, made the incredibly courageous decision to come forward to the Clute Police Department in September 2023.
So almost 17 years had passed since the abuse began.
17 years. And this case is just a stark reminder of how long it can take, how long some victims need before they're ready to speak.
And once the report was made, it seems like the gears of consequence, at least on the school district side, started turning pretty quickly.
Oh, almost immediately, yeah. Brazosport ISD was notified almost instantly by the end of September 2023. Hargrove was placed on immediate administrative leave.
And then fired.
Well, once the formal indictment came down, the district started the process to terminate her employment. And they finalized that in early 2024. But, the legal path forward was much more complicated than the administrative one.
Okay, so this is where it gets really fascinating, legally speaking. In December 2023, she was indicted on 12 felony counts. That number alone it's huge.
12 felonies.
Yeah.
All related to the abuse. And the breakdown was specific. 6 counts of sexual assault of a child, 4 counts of indecency with a child by contact, and 2 counts of indecency with a child by exposure.
Just so people understand, what does that mean in terms of severity?
Well, to be clear, the sexual assault and the indecency by contact charges are second-degree felonies in Texas.
Okay.
And those typically carry potential prison sentences of 2 to 20 years.
Each. So prosecutors were really throwing the book at her. But why these specific, incredibly severe charges instead of something more direct like educator misconduct?
That is a crucial legal nuance. And the police chief, James Fitch, he clarified this. The fact is, back in 2006 and 2007, when this was all happening,
right,
Texas law didn't have the specific charge of improper relationship between an educator and student. That was added later.
Oh, I see. So to seek justice for the victim, they had no choice. They had to use the existing heavy-hitting criminal statutes.
Precisely. Sexual assault of a child and indecency with a child. So paradoxically, because the crime happened before that specific educator law existed, the charges she faced had to be legally more severe.
And they had to rely on that broader definition of assault.
They did. And this point is really underscored by the graphic detail included in the indictment. One of the counts specifically accused Hargrove of assaulting the victim with a cucumber.
And you include a detail like that because it shows the strength of the testimony.
Exactly. It shows the comprehensive nature of the evidence they had. It tells you that prosecutors were backing up those 12 counts with very specific, very detailed victim testimony.
And none of this, not the indictment, not the charges, none of it would even be possible without one very specific and very powerful piece of Texas law.
That's the real legal backbone of this entire case. And we have to reiterate this for you listening. Texas has no statute of limitations for sexual assault of a child or indecency with a child.
Zero.
Zero, which meant that even though the crimes happened in the mid-2000s, the passage of 17 years did not stop the state from prosecuting. It's a mechanism specifically designed to protect victims who often can't or won't report for a very, very long time.
So after the indictment, Hargrove was booked into the Brazoria County Jail in December of 23.
She was. But she was released the same day after posting a pretty substantial bond, $240,000, to await her trial.
Okay, now we get to the resolution phase. And again, another major surprise. In August 2025, Brandon Hargrove pleaded guilty to all 12 felony charges. And I was struck by the fact that the police chief himself said he was surprised. He expected this to go to a full trial. So why plead guilty to a dozen felonies? And more importantly, let's dig into the plea itself. What did she actually agree to?
Well, you could say she was playing a very high-stakes game of legal chicken, and she blinked. The guilty plea guaranteed the state a finding of fault, right? Without the risk of a trial, which can be immensely re-traumatizing for the victim.
Of course.
But in exchange, Hargrove received a sentence structure that kept her out of a physical jail cell.
Wait, hold on. 12 felony counts, including sexual assault of a child, and the outcome is 0 time behind bars. How is that? How is that even possible under Texas law?
It's possible through the strategic use of 2 related but distinct legal instruments: deferred adjudication and a fully probated sentence.
Okay, break that down for us. What is deferred adjudication?
So for the 10 second-degree felonies, she received 10 years of deferred adjudication. Think of it as a kind of legal tryout. The court delays a final finding of guilt. It doesn't officially say you are convicted as long as she successfully completes all the terms of her probation.
So if she walks the straight and narrow for 10 years, do the convictions just disappear?
In many non-sexual offense cases, yes, the charges can be dismissed. But, and this is a critical caveat here, for specific offenses, including the ones that require sex offender registration, the underlying factual guilt and that registration requirement, it's permanent, even under deferred adjudication.
It sticks with her.
It sticks.
And what about the other 2 charges? The third-degree felonies?
For those, she received a 10-year prison sentence, but that sentence was immediately suspended. Instead, she was given 10 years of traditional probation. So across the board, the outcome was 10 years of state monitoring, not incarceration.
So it's a trade. The state prioritizes a guaranteed registration and lifetime monitoring over a trial that could be costly and risky.
That's a very common strategy in these complex plea deals, yes.
But even with all that legal maneuvering, the victim's voice was central to this outcome, right? I read the district attorney's office consulted with her.
Absolutely. And her impact statement in court was, it was incredibly powerful. It was the human core of this whole resolution.
What did she say?
Her statement really captured the profound damage, but also her journey to reclaim her own narrative. She said, and I'm quoting here, "Brandon, I face you today as the adult who now protects the child you once exploited and betrayed. You didn't just break boundaries, you broke a person." And then she ended with, "Today I go from victim to survivor, victim to victor." It emphasizes that the resolution, for her, wasn't necessarily about Hargrove's prison time, but about her own ability to stand up as a survivor.
And while prison time was avoided, the permanent legal consequences she now faces are incredibly restrictive. They're going to affect every aspect of her life from here on out.
That is the trade-off. The most substantial consequence is mandatory lifetime registration as a sex offender in Texas. This isn't temporary, it's permanent.
What does that actually mean day to day?
It means massive restrictions. Restrictions on residency. Often she's prohibited from living within 1,000 feet of places where children gather, like schools, parks, daycare centers.
And employment, obviously. She can't go back into a classroom.
Absolutely not. Texas law, specifically Article 62.063 of the Code of Criminal Procedure, immediately bars her from employment in any primary or secondary school, any child care facility, or even coaching.
So even if she needed to go to a school for, say, a parent-teacher conference for her own child one day,
even then, she would be legally required to notify the administrative office of her presence and her registered status beforehand. Her life is now monitored and restricted by the state, indefinitely.
Okay, this brings us to what might be the most fascinating and frankly troubling part of this whole deep dive. A policy contrast in Texas. The sources you found highlighted a similar case, right? A Carol Turner.
Yes, the Turner case is essential for context because it reveals this administrative inconsistency in how Texas handles educator accountability. Turner was a former band director in Crum ISD, and she also pleaded guilty to similar felony counts dating back to the 1990s.
And she also got deferred adjudication?
Correct. She also avoided prison. But her administrative outcome was totally different. In her case, the Texas Education Agency, or TEA, did revoke her teaching certificate, and she was added to the state's Do Not Hire registry.
Okay, so let's bring this all back to Hargrove. We've established she pleaded guilty to 12 felonies against a student. She was fired by her district, and she's a lifetime registered sex offender. So what is the current status of her professional teaching license?
This is the massive disconnect we need to spend some time on. Despite that comprehensive legal outcome, despite her lifetime sex offender status, Brandon Hargrove's teaching certificate in the state of Texas remains valid.
What?
It's still valid. And furthermore, she has not yet been placed on the state's Do Not Hire registry.
How is that possible? If the court outcome was essentially the same deferred adjudication for these horrible felonies, why did the state revoke Turner's certificate but hasn't touched Hargrove's?
The simple answer is procedural delay and regulatory complexity. That deferred adjudication status, it complicates the TEA's ability to act automatically.
So they're waiting for something.
It seems so. While our district fired her, the state licensing body often waits for the completion of the deferred period, or it requires a whole separate administrative process to determine good moral character or fitness to teach, even when a court has already established factual guilt in a felony case.
But that seems like a massive policy gap. She is legally permanently barred from ever working in a school. So why is her license to do that exact job still recognized as valid by the state?
It creates a bureaucratic headache, and it undermines public confidence, A valid certificate suggests the holder meets all the state's professional standards.
Which she obviously does not.
Clearly not. In this specific scenario, the administrative mechanism, the TA's ability to revoke, is lagging far, far behind the judicial and public safety mechanisms, like the sex offender registry. It just raises the question, is the state doing enough to instantly disqualify educators who plead guilty to these crimes?
That really is the lasting implication here. But before we get to our final thought, we should highlight the main takeaway for other potential victims, which came right from the Clute Police Department.
Yes, Chief Fitch's message after the plea was so critical. He stressed that victims should never, ever hesitate to come forward, no matter how much time has passed. He was adamant that this case proves law enforcement will commit its full resources to seek justice even 17 years later, all thanks to that specific aspect of Texas law.
So this deep dive, it's given us some huge takeaways. First, the incredible power of a victim statement to finally seek resolution, and how Texas law can make that prosecution possible years and years after the fact.
Second, we saw the surprising tactical use of deferred adjudication in these severe felony cases, a strategy that guaranteed Hargrove's lifetime sex offender registration while avoiding the risks of a trial.
But the final thought, the one we have to leave you with, it circles right back to that policy puzzle, the one that goes way beyond just this one case. So, considering Brandon Hargrove pleaded guilty to 12 felonies, is a permanent sex offender, and is legally barred from ever working in a school again, what are the immediate and the long-term implications for student safety and public trust when that same person can still hold a valid teaching certificate in the state of Texas?
It's a profound inconsistency that really demands some policy attention. It makes you wonder where the administrative red tape ends and where true accountability actually begins. Something to mull over until our next deep dive.